Hello and welcome to LiveLaw Daily. Today is the 21st of July, and from the Supreme Court to High Courts across the country, it's been another busy day in the courts. So here is everything you need to know. First up, the Uttarakhand High Court came down hard on the state police over the detention of Uttarakhand Parivartan Party President Prabhat Dhyani, demanding to know under what authority he was stopped while travelling to Delhi to join a protest. A division bench of Justice Ravindra Maithani and Justice Siddharth Shah heard a habeas corpus petition challenging Dhyani's detention after he was intercepted while travelling from Rishikesh to New Delhi to join Cockroach Janata Party's march towards Parliament. This was in support of students protesting the alleged NEET paper leak. The state defended the detention as lawful, arguing that Dhyani had publicly announced on social media that he intended to join the march and relied on Section 163 of the Bharatiya Nagarik Suraksha Sanhita, which empowers executive magistrates to issue urgent preventive orders for public order. It further argued that while protests at Jantar Mantar were permitted, no permission had been granted for the march to Parliament itself. The bench was not having it though, asking under which law. The court pointed out that Section 163 was not even in force in Uttarakhand and questioned how state police could stop someone from travelling to Delhi for an event that would fall within Delhi police's jurisdiction. When the state argued that it could act if a cognizable offence was likely anywhere in the country, the court called the interpretation extraordinary, asking, "Who are you? You're not the Delhi police." The bench did not stop there, remarking that the police action looked like Gunda Gardi and warning that stopping citizens from travelling simply because they intended to join a protest would amount to anarchy. It reminded the state that India is governed by the Constitution and that Articles 19 and 21 protect the rights to free movement and personal liberty, also brushing aside the state's attempt to invoke national security, observing that in the name of national security and Sarkar ki chhavi, don't harass people. The High Court has now issued notice to the state authorities directing a response within 4 weeks. The petition also seeks preservation of CCTV footage and production of all records relating to Dhyani's detention, which the petitioner alleges was carried out without due process. Next up, the Supreme Court has decided that the Supreme Court Bar Association's electoral reforms won't apply to the upcoming 2026-2027 elections. The new framework will kick in only from 27 to 28 cycle instead. A bench of Chief Justice of India Suryakant and Justice K.V. Vishwanathan accepted a unanimous request from the bar, who argued it would be unfair to introduce a new eligibility condition after the electoral roll had already been finalized in May, with a cut-off date of February 28, 2026. The court accordingly directed that the 2026-2027 SCBA elections should go ahead under the existing rules, setting aside its earlier direction to implement reforms immediately. It also instructed the election committee to notify the schedule so polling happens around August 18th, with the newly elected executive committee in office by August 21st. The reforms in question include new voter eligibility criteria tied to appearances before the Supreme Court, along with a 2-year tenure for office bearers, among other changes meant to strengthen the association's electoral process. While pushing back implementation, the bench clarified that the election committee won't become functus officio after the 2026-2027 elections. It will keep operating, tasked with getting the groundwork done by December 31st, 2026 and finalizing the electoral roll for 2027-2028 by February 28th of 27 ahead of polls slated for July 2027. And for our third story today, the Supreme Court has indicated that Sonam Raghuvanshi, the prime accused in the Meghalaya Honeymoon murder case, should think about surrendering and facing trial, while also raising serious doubts about the legal basis on which the High Court granted her bail. A bench of Justice M.M. Sundaresh and Justice P.B. Varale was hearing the Meghalaya government's appeal against her bail, and the bench repeatedly pressed on why Sonam had not raised the non-supply of grounds of arrest plea at the earliest opportunity, and questioned how a clerical error in the arrest memo could on its own justify her release. The High Court had granted bail after finding that the arrest documents kept referring to a non-existent Section 403 of the Bharatiya Nyaya Sanhita instead of Section 103, treating it as evidence of non-application of mind. The Supreme Court, though, felt the issue needed closer scrutiny and indicated that it was leaning towards either deciding the appeal on merits or asking Sonam to surrender while the trial proceeds. Justice Sundaresh told her counsel that surrendering might be the better route, adding that if she did, the The court could direct the trial court to record the evidence of public witnesses first and then take up her bail request again. Solicitor General Tushar Mehta for the state argued that the wrong citation of Section 403 was purely a typo and did not mean that the grounds of arrest had not been communicated. He also pointed out that Sonam had never raised the non-supply issue before the magistrate or in her earlier bail applications, only much later. The Supreme Court made it clear that it wasn't examining the prosecution's allegations on merits at this stage. The matter is now posted for further hearing on Thursday. And for a fourth story today, the Delhi High Court has ordered activist Sonam Wangchuk shifted from Safdarjung Hospital to Medanta Hospital in Gurgaon, holding that the move would protect his fundamental rights while he continues his hunger strike. A division bench of Chief Justice D.K. Upadhyay and Justice Tejas Karia disposed of an appeal by Wangchuk's wife, Dr. Gitanjali Angmo, against a single judge's refusal to permit his transfer to a private hospital. Before ruling, the bench went through the medical reports from Safdarjung, AIIMS and a private laboratory, and spoke with doctors from AIIMS, Safdarjung and Wangchuk's own physician. It noted a broad medical consensus that he needed continuous monitoring, particularly given concerns over his potassium levels and white blood cell count during the ongoing fast. The court held that shifting Wangchuk to a hospital of his choice would satisfy the requirements of protecting his rights under Articles 19 and 21 and recorded Solicitor General Tushar Mehta's statement that the union government had no objection to the move. It accordingly directed his immediate transfer to Medanta, where specialist doctors will continuously monitor him and administer treatment per accepted medical protocols. Dr. Angmo has been granted unrestricted access to her husband during his hospitalization, subject to medical protocols, while Wangchuk has been asked to cooperate with the treatment advised. The court stressed that its only concern throughout was Wangchuk's life, safety, and fundamental rights, and disposed of the appeal on that basis. For a fifth story today, the Supreme Court has expressed reluctance to take up a public interest litigation seeking a standard investigation procedure and time-bound mechanism for probing exam paper leak cases nationwide. A bench of Justice P.S. Narasimha and Justice Alok Aradhe heard the petition filed by Advocate Ashwini Kumar Upadhyay, seeking a uniform questionnaire and special investigation protocol for leaked paper cases, particularly in light of the recent NEET controversy. The bench orally observed that this may not be a matter for the court to consider, pointing out that it's already seized of petitions dealing with broader concerns around the National Testing Agency's conduct of NEET. Still, on the request of Senior Advocate Vikas Singh for the petitioner, the court agreed to defer the matter by a week so it would be taken up after the pending NEET cases. The petition argues that despite the Public Examinations Prevention of Unfair Means Act of 2024, real gaps remain in this system. No statutory timelines for investigation or trial, no standard investigative procedure, and inadequate mechanisms to catch the masterminds behind repeated paper leaks. Among other things, the petitioner wants laws like the Prevention of Corruption Act, the Prevention of Money Laundering Act, and the Benami Property Act invoked against those involved, along with confiscation of their assets. The Supreme Court will take this up after hearing the pending NEET petition. For our next story today, the Shiv Sena faction led by Uddhav Balasaheb Thackeray has moved the Supreme Court against the Lok Sabha Speaker's decision approving the merger of 6 of its members of parliament with the Eknath Shinde-led Shiv Sena. The matter was mentioned before a bench led by Chief Justice of India Suryakant by Senior Advocate Devdutt Kamath, seeking an urgent hearing. Kamath stressed that the Speaker's decision had brought his clients functioning as a political party in parliament to a complete standstill, especially with the monsoon session underway. The Chief Justice did not commit to an immediate listing, but said that the court would consider it, remarking that they can't promise, but they'll see. As per the challenge, Lok Sabha Speaker Om Birla approved the merger of 6 Shiv Sena UBT members of parliament into the Shinde faction ahead of the current session, leaving the Uddhav Thackeray-led Shiv Sena down to just 3 members of parliament in the Lok Sabha. The Supreme Court will now decide whether the challenge needs urgent consideration during the ongoing parliament session. And for a 7th story today, the Karnataka High Court heard a petition alleging a disturbing pattern of unnatural deaths and disappearances in and around Dharmasthala, with several bodies allegedly buried without following mandatory legal procedure. A division bench heard the public interest litigation filed by the mother of a girl allegedly raped and murdered in the Dharmasthala. It seeks directions to locate suspected burial sites, exhume remains, identify victims through DNA testing, determine cause of death through forensic examination, and ensure a thorough investigation into each case. Advocate Vrinda Grover for the petitioner argued that there had been repeated violations of Section 174 of the CRPC and the Karnataka rules governing investigations into unnatural deaths. Referring to the 74 cases that she had compiled, she said several dead bodies were buried or cremated within a day of being found, often without proper inquests, post-mortems, or even basic details like identity, age, or gender being recorded. To illustrate the pattern, Grover pointed to cases involving bodies found in lodges, forests, and guest houses where deaths were quickly written off as suicides or unidentified cases before the remains were disposed of, making it impossible, she argued, to rule out homicide in some of them. She also relied on the special investigation team the Karnataka government constituted in July 2025, submitting that it has the authority to investigate all such cases and report progress periodically. The state government sought time to respond, saying that the Advocate General was tied up in another matter. The court accepted the request and posted the case for further hearing on August 24th. And finally today, the Karnataka High Court has stayed further investigation against a law student booked in 2 FIRs over a social media post on the recent Bantwal bus stand murder, saying that the authorities should be focused on investigating the crime itself, not the student's comments. Justice M. Nag Prasanna granted interim relief to the 6th semester law student who had posted on X that the accused in the murder case would probably escape punishment because the Congress government would quietly withdraw the case. That post led to 2 FIRs, one under Section 353, subsection 2 of the Bharatiya Nyaya Sanhita relating to statements promoting public mischief, and another under Section 192 of the BNS, following a complaint from a political party worker who claimed that the post tarnished the ruling party's image. During the hearing, the court remarked that the real concern should be the investigation into the brutal murder, not the student's tweet, noting that the post was being given an unwarranted communal color despite no express reference to any religion, community, or identifiable group. In its order, the court said that if the tweet had even remotely promoted communal hostility or hatred, it would have let the investigation continue. But on a plain reading, it found that the essential ingredients for the invoked penal provisions simply were not there. The court also noted that the student's suggestion that the government might withdraw the case was not baseless. A division bench of the same High Court had previously criticized the state government for withdrawing criminal prosecutions. Finding a prima facie case in the student's favor, the High Court stayed further investigation in both the FIRs pending closer examination. The petitions will now be heard again on August 7th. And that's all for today's edition of LiveLaw Daily. If you'd like to read any of these stories in detail, you'll find the links in the description box below. For continuing coverage of the courts and the law, visit livelaw.in. Thank you for listening and keep following LiveLaw to stay updated with everything that is law.